The honourable member for Nelson.
Thank you, Mr President. And I do rise to speak on this bill, the Residential Parks Bill 2026. And it will be a start, I suppose, because I'm not entirely ready to give a considered contribution on the bill as yet. But we did have the benefit of an excellent briefing earlier today, and I thank the department staff for providing that. So I do feel now at least I'm able to begin some remarks about it and share some thoughts on my views on the bill. It's such an interesting topic, to be honest. I haven't delved into this area and this rather unique housing type in great detail before, and so it has brought things to my attention that, thank you, that I wasn't fully aware of previously. And clearly what we've got here is a potentially very complex set of circumstances around this form of housing, and I would definitely start by saying that I'm a firm believer, and many here would have heard me speak before in different contexts, on my firm support for human rights and protecting the human rights of Tasmanians via a Human Rights Act. One of the key human rights that would be enshrined in such an act would be a right to housing, because housing is fundamental. It's absolutely foundational to a good life, really. Everything else that you might need to be participating in or having as aspects of your life, whether it's family life, whether it's health and wellbeing, whether it's employment, education, whatever, it all has to have a foundation of a safe and secure home. So housing tenures are critical to whether we are delivering on that human right in our state. And this is an interesting circumstance because from some perspectives, there'll be cases where the housing tenure we're talking about here, where we've got a permanent-ish dwelling in a caravan park environment. For some, that is a long-term, safe, secure housing opportunity. For others, it's a more temporary housing opportunity that isn't necessarily secure and able to be contemplated as a long-term option. And it's potentially quite a highly vulnerable housing tenure to be in for Tasmanians. And so I think it's quite fascinating, as we've learnt through considering this bill and discussions in our briefings and the like, and from what's been said here, it's quite fascinating that we haven't really had a clear line of sight on exactly how many Tasmanians might live in these circumstances. We get some information through census data that's not necessarily fully reflective of what might be the reality out there across our state in different communities. And that tells us something too. When we don't fully know the circumstances around something that's very fundamental, a particular housing tenure, it's likely we might not be fully aware of what's required there in terms of not just rules and regulations and that sort of strict side of it, but also perhaps support and services that might be needed into those spaces as well. So this is, I think, really valuable on a few fronts there. It's a valuable bill because it's, I think, as the leader mentioned in the government's second reading speech, we've had quite a tapestry of arrangements and quite some uncertainty around how those knit together. And so what we're tackling here is trying to put something much more clear and comprehensive, something that's much more fair and reasonable, that provides protections but also provides confidence for everybody involved, and that's really valuable. It's sort of surprising it's taken us this long, actually, in a way, Mr President. So here we are. What I'm gathering as I've been contemplating and grappling with this bill, because it's a quite lengthy bill and quite complex, as a member for Mersey had mentioned, it's a lot of legalese, I think was a term he used at some stage on it, a lot of detail in the bill, but it does come to provide for us something that's at least consistent and clear as a framework that will better protect everybody involved. It will better protect those people who are residing in this form of housing tenure to ensure their rights are respected and at least clear. It will better protect the park owners and the people who are offering these agreements for the land on which the dwellings are located. And so I think from all sides it should be a win-win. Mr. President, of course, my interest is always going to be, are we also better supporting and protecting the people in any given circumstance who might be in the more powerless situation? And for me, that's probably always going to be tenants or people who are not the asset owners. In this case, we've got a funny mix of asset owning, don't we? We've got the land on which the dwelling exists as the park owner owning that, and then we've got the person who has a dwelling on that, temporary, sort of temporary, but also becoming more permanent and long-term as bits are added to it. That's an asset to own too. So you've got assets owned on both sides, but in some ways the person who owns the land is always going to be in the more powerful position. So this helps to clarify and ensure that interplay of power doesn't get unbalanced or go in the wrong direction. So I'm quite pleased about that. Certainly the protections around having to have agreements in writing. There's a really basic, straightforward requirement. Agreements around, arrangements around how agreements might be terminated between the two parties, a really important set of structures to put in place to provide protections. One of the things I was quite pleased to hear about in a bit more detail in the briefing was the fact that this process to develop this bill has been quite comprehensive. I think we're all aware that there were a few things that have been occurring in certain communities and in certain particular caravan park environments that have prompted us having to go down the path of getting this sorted out. But the process has been quite comprehensive by the look of things. We've had a look at other jurisdictions, identified South Australia as a model that had a lot of useful elements to build on, taken that, adapted it to circumstances here. An exposure draft has gone out. There's been a lot of engagement with that and worthwhile engagement because we've also heard that changes and improvements were made as a result of that consultation. So what we've arrived at now, even into this place, having come through the other place, having some more amendments made, we've arrived at a bill that I think has gone through a fairly rigorous process and come here for us to contemplate. And so that's why I think it does quite well to get the balancing right and to get those protections in place. I think as it goes through this place, and if and when down the track we get to the committee stage, I think there's even further amendments to consider, not from me, Mr. President, but by the sound of it from the government and perhaps others. So we will have an opportunity to consider some nuance and some potential improvements, and that's even better. Excuse me. So as I was saying, I think that the particular strengths here that make my ears prick up, I suppose, or catch my eye as I'm going through, relate to protections around termination. We know that people entered into agreements about the place where they live, whether that's under the Residential Tenancy Act or whether it's under agreements that are detailed in this bill, are quite vulnerable, particularly at the time if there isn't clarity around grounds on which they can be terminated under that agreement. So to see here laid out quite clearly and quite reasonably circumstances under which that can happen, and most importantly, to see included in the bill the appeal facility there, to go to TASCAT and have disputes resolved or have an appeal level. It provides administrative justice, I suppose, to people involved, that not only do they have clarity in what will be the rules around this, but they have somewhere to take that if they dispute what's being done in their circumstance. That's a really positive development too. I do note the government indicates that it certainly was an aim that this bill wouldn't introduce measures that were too burdensome for park owners, and I think that's a reasonable aim to have with this bill. I found it quite interesting to hear the member for Mersey in his contribution talk about his family member who is a park owner and operates in this space, and in fact has a large community of permanent residents there in different types of dwellings on his property. And that was really interesting to hear about, particularly what sounds like the lengths that he and his family go to ensure that that community is a safe and supportive community, that it's one that engages with each other in a really positive way and supports each other. I think what that shows is, and it's probably not an uncommon story, that there would be a lot of very well-intentioned and very responsible and caring park owners. But of course, Mr President, we can't legislate on the basis of assuming everybody is going to be like the member for Mercy's family member. So what we do need to have is circumstances that somewhat assume that the opposite might be the case, and we might have to protect against it. And I think that
sometimes they are not very
sometimes
nice.
they are.
They're not nice.
Look, this is the world we live in.
It's my brother, I'm sure.
We're not reflecting on your brother in any negative way. So what we need to see is that we're not imposing things that are too burdensome and assuming everybody is going to be terrible, but we have to accommodate the fact that there will need to be relatively clear and relatively easily enforceable rules around protections. As I said, the power dynamic is an important factor there, for sure. I do note again too that, and this is very positive, I think, from both sides, more structured arrangements around what we would call a bond, but I think in here it's called a security bond. No, security, oh gosh, I've got a deposit. There's my notes, there they are, Mr President. Security deposit. And formalising the fact that that now needs to be collected but lodged in a central way through CBOS, like we do under the Residential Tenancy Act for private rental market rental arrangements. And that makes a great deal of sense, I think, to have that more formalised at arm's length from the park owner, and a very clear set of rules around the basis on which you might have some security deposit withheld, the circumstances that can apply to. Of course, it can't be exactly like we have under the Residential Tenancy Act because the dynamic is a little different, but the bill spells it out quite clearly, those elements that can come into play when somebody wants to retain some security deposit for certain matters. Certainly, if people have left a great deal of detritus around the dwelling when they've come to the end of the agreement and have moved on, that's going to be problematic. Anything within the dwelling or for the dwelling itself, of course, is the responsibility of the owner of the dwelling. So if somebody's sold their dwelling, that's on the new owner. But if they've left the lease agreement at a time that they've left a total mess around it on the property, on the land, then that's going to be something, for example, that's a basis on which to withhold some security deposit, I gather, from the bill. I find that the government's been quite responsive in terms of tweaks made, amendments made in the other place that related to a staged commencement of some bringing into play, implementing these rules around security deposits. I think that's sensible because we just do need to set up admin systems in order to appropriately implement what's in the bill. So I understand why that's put in as not being switched on straight away on royal assent, but will come in as a staged commencement. I think we've given ourselves 6 months to do that potentially, or the intention is for it to be that period of time. Another aspect of the bill that I found quite interesting, because again it's quite unique to these sorts of circumstances and isn't mirrored in, say, the Residential Tenancy Act, was around the matters in the bill that relate to residents' committees. Now that's quite a fascinating situation, Mr President, around residents' committees. That in fact the bill establishes that not only can they exist, but there's sort of some expectations around the fact that the park owner must take measures to encourage and support them to exist, and in fact can be penalised for not doing that. Must take all reasonable measures to ensure that if there are more than 5 agreements relating to these residences on their property, that that a residents' committee can be established. It's an interesting thing to have a penalty in a bill for somebody to have to take steps to ensure a committee comes about that they themselves aren't going to be a member of, that they can't go and obviously twist arms and tell people they must be a committee member, but they must at least take steps to encourage that to happen and to facilitate it to happen. All reasonable steps. And that's practical things like having a meeting room that is sufficient for people to meet in as a committee, making sure that information about a committee is available to all relevant residents. And I assume there's probably a short list of other things that might be regarded as reasonable steps as defined in the bill, or as specified in the bill. I think, Mr President, it does make sense that residents' committees would be a valuable aspect of this sort of arrangement. I can imagine in the larger sort of parks, such as the one member from Mersey spoke about with his brother, where there was, I think he mentioned 70 or 80 residences there, then you could have a very substantial, very vocal residents' committee, no doubt, with a serious bit of heft behind it when you bring, potentially 50 different residents' voices together. I imagine those providing a meeting space for them would be an interesting challenge in and of itself. But it does mean that matters can be considered as a group then. Concerns can be addressed and brought forward as a group, which is interesting. And I think, again, in that dynamic between the park owner and the residents who are entered into agreements for these dwellings, we can see that would have a lot of benefits. I do note that in the bill, it establishes, I think it's in section 91, park rules can be made, and it suggests some areas that park rules could be made in. Let me just bring that to my mind so I can make a couple of comments about that. What I'm imagining, Mr President, and I think this is true of a lot of the bill, to some extent the bill is likely to be codifying what many well-intentioned, reasonable, competent park owners and residents are doing already in these arrangements between them. But of course it doesn't hurt to codify it, and it doesn't hurt to make sure that there are avenues of recourse if things go astray. We know in the dynamics between groups of people, there's always a possibility for things to go astray. So I think the provision for the park owner to make rules for the use, enjoyment, control and management of their park is a good thing to have stated and codified here. It does, however, then limit the list of things that the rules may be able to be made about. And I think that's useful too, because sometimes, I don't know what it's like in your house, Mr President, but sometimes it can be handy, especially when children are younger, to make up rules to suit you as a parent as you go along to help manage behaviour. So a rule that didn't exist yesterday might come into play.
My rules in my house.
That's right. And so sometimes if you're in a position of power and you're able to make up the rules a little bit as you go along, that can be inappropriately punitive. It can be a way of actually forcing people out, or it could be a way of making people's lives very, very difficult so that they feel they need to go. That's the sort of behaviour I presume we're trying to address here by actually just outlining the areas that rules can be made on. And one that jumped out and got a little bit of discussion in the briefing was around the keeping of pets. And it's worth just noting here that unlike what we've recently done under our Residential Tenancy Act, very laudably and finally, actually, in keeping with other jurisdictions, we've now, in our private rental market under our Residential Tenancy Act, made it that the presumption is you can have a pet in a private rental under a lease, private rental lease, unless there's certain circumstances where that may not be allowed, and those are fairly closely prescribed circumstances. Here, there isn't going to be an onus that there must be a presumption that there can be pets accommodated in these dwellings as part of these agreements. However, the park may set its rules around that, and then it may be individually, park by park, something that parks allow. I think that's sensible. I'm a big proponent of the fact that people should be able to have pets where they're living if it's appropriate for them to have pets and they dearly wish to. It's a very positive health and wellbeing measure for households to have pets as part of their family, and we all know that a lot of good can come of that. But I think, given that what we're doing here is a bit of a first step towards addressing this strange tapestry of things and trying to make it into a cohesive set of rules and approaches, this is probably a step one. And once we get this in place, see that it's working well, find out what we don't know and haven't done yet to formalise it appropriately and get it straightened out, the issue of perhaps a presumptive obligation to allow pets might come down the track when we can get a better line of sight on what that might best look like, or how best to frame that in this context. So I would still be hopeful that we might end up at a place that wherever possible, Tasmanians living in whatever housing tenure they live in can have a right to have a pet as part of their home, as long as we've accommodated the exceptions that need to be there in different circumstances as well. That might come. It will be interesting to see, and actually I don't know that it came up in the briefings, and perhaps because I've had a fairly cursory look at the bill so far, Mr President, I might have missed it, but this could be a question that can be answered later when we finally get to a summing up one day on this bill. Is there intended to be some form of review or assessment of this legislation a certain distance into the future? It might not be something, I don't see it in the Act, it might not be something that's a legislative review formalised in the bill, but perhaps the government can indicate whether there's an intention. How will we know how this is going as we implement it? How will we make an assessment at an appropriate distance in the future on whether it's successfully achieved what we would want it to achieve, what the stated goals were? Is that something that's planned, and if so, how might it happen? That would be useful to just hear back about in the leaders summing up down the track. Now, back to my notes, Mr President. I'll have a drink while I have a break. There's some really practical things in this bill, and one that I'll point to, and again, it's because it's a protection of potentially vulnerable people in these circumstances, that I really like, is that the bill formalises things like there can't be extra charges laid on additional things and brought in down the track unexpectedly for people, or perhaps used to be punitive or to be trying to drive somebody out, keeping on adding extra costs to things. That's really good. So, for example, they can't just decide to start charging you extra because you happen to have visitors arriving at different times, or that you need to pay extra if you want to have a tradesperson come in and do work in your house, or whatever it might be. That can't happen under this bill, and I think those sort of practical protections are important. The other thing I was pleased to hear, and it did get some discussion, Member for Mercy, of course, I think pointed to this very clearly and raised it in the briefings also, that because this is a fairly substantial piece of legislation with a lot of complexity to it, it will then have to then be brought into the real world and understood and utilised by at least the two groups of people directly impacted, the park owners, and by residents and potential residents in these dwellings. So we will need to have very good resources, accessible, plain language resources in different formats for people to be able to understand their rights, their obligations, how things will work. I do note that there's going to be a range of standard materials developed flowing from this bill. So, there'll be some standard agreements available and accessible for people to utilise if they wish to do so. So not everyone has to figure out if what they've drawn up aligns with the requirements of the Act. There'll be something that CBOS can provide to people as, here's your stock standard one, you can adapt it if you need to, but it meets the requirements of the Act. other sorts of fact sheets, other sorts of information provided, whether that's via little videos, whether it's via social media sorts of information. I believe there's an intention for there to be some sort of advice line or phone number that can be called for people if they've got questions. All of that's really useful and important. It will be very interesting, I think, down the track if we are to be assessing how this is tracking, whether it's achieving its aims. I'll be particularly interested to hear what feedback has come back from both those key stakeholder groups, the park owners and also the residents in these circumstances. Because although we did have those particular in recent years, these examples where there were certain sorts of contentious things going on that prompted this to come about, what we hope is that once it's in place, of course, it not only helps things work well, but it's preventative of not having contentious situations arise again, Mr. President. So I'll be interested to see whether both sort of sides of the equation feel that the bill is achieving those ends as we get further down the track with it being in place. Now, there's no doubt, Mr. President, there might be some other things I'd like to say on this bill, but have not yet quite formulated them because I haven't had a comprehensive look. And it certainly is a bill that, to my mind, because of its complexity and size, will take us a bit of time, I would think, in committee stage, should it go through to committee stage, as I do expect it will. And it will be a valuable service that this chamber does in our committee stage on this bill to get the right amount of clarity, the right amount of information on the parliamentary record as we go clause by clause through the bill. And so I'll be pleased, certainly, to have more time available to prepare for that process. So with that, Mr. President, for today, I think I've finished my remarks. And so I think, given that we're at a stage where no other members are quite ready yet to do their contributions, I'm going to move that the debate stand adjourned.